Consider what unfolded this week in a federal courtroom, a moment that reveals much about the fragility of institutional restraint when ambition eclipses constitutional duty. A federal judge delivered a stinging rebuke to Speaker Mike Johnson, dismantling his legal rationale with language rarely directed at so senior an officeholder. The ruling has not merely unsettled the Republican caucus, it has exposed fissures within a coalition already strained by competing loyalties and constitutional shortcuts. The jurist employed terms such as constitutionally indefensible and flagrant abuse of authority phraseology that signals more than routine judicial disapproval. This represents a categorical rejection of Johnson's conduct, a repudiation that carries weight precisely because it emanates from the judiciary, not the partisan arena. History reminds us that when courts speak with such clarity about abuses of legislative power, the reverberations extend far beyond the immediate litigants. The spectacle now unfolding among conservative commentators, Trump loyalists, and media personalities suggests that the ruling has fractured whatever consensus sustained Johnson's gambit. When allies turn upon one another, it is often because the ground beneath their shared assumptions has shifted irrevocably. The particulars merit attention. Johnson assumed the speakership in October 2023, following Kevin McCarthy's ouster at the hands of the party's insurgent faction. From the outset, he fashioned himself as an unbending champion of the former president's agenda, orthodox in ideology, unyielding in loyalty, and prepared to subordinate institutional norms to partisan imperatives. Whether obstructing oversight inquiries, declining to advance legislation, or weaponizing appropriations debates, Johnson operated as though the speakership existed chiefly to serve one man's political fortunes. He amplified every grievance, defended every controversy, and signaled unmistakably that his tenure would privilege factional ambition over deliberative governance. Yet political calculation, however bold, eventually collides with constitutional architecture. Johnson made a choice that has now detonated with spectacular consequences. According to contemporaneous reporting by Politico on November 15th, the Speaker refused to seat Adalita Grava, a Democrat elected to represent Arizona's 3rd congressional district, notwithstanding her uncontested victory 28 days prior. The constitutional question before us is straightforward. When a citizen prevails in a lawful election, does the Speaker possess unilateral authority to nullify that outcome? For more than 2 centuries, the answer has been clear. Victorious candidates present themselves on the appointed day, take the prescribed oath, and assume the duties entrusted to them by their constituents. Johnson, however, arrogated to himself a power the Constitution does not confer, asserting that alleged electoral irregularities justified indefinite exclusion pending further inquiry. A serious republic must ask, by what precedent does one individual override the expressed will of the electorate? The House maintains established procedures for contesting elections when members harbor legitimate doubts about a seat's disposition. Those mechanisms exist precisely to prevent arbitrary exclusion robed in procedural pretext. Johnson circumvented them entirely, substituting his personal judgment for institutional process. The consequence? Approximately 800,000 Arizonans found themselves stripped of representation in the national legislature. Reflect on that for a moment. Nearly 1 million citizens rendered voiceless because a single officeholder decided that constitutional norms could be suspended for partisan advantage. This sequence of events drew the scrutiny of Arizona Attorney General Chris Mayes, who assessed Johnson's conduct and concluded it transgressed constitutional boundaries. As MSNBC reported on November 17th, Mace initiated federal litigation demanding Grava's immediate seating, contending that Johnson had violated not only the Congresswoman-elect's rights, but also the constitutional entitlement of her constituents to legislative representation. The judiciary moved with uncharacteristic dispatch. Recognizing that each passing day compounded the injury, citizens denied their voice during pivotal budget deliberations and consequential legislative proceedings. The urgency was institutional, not merely procedural. When the court issued its judgment on November 19th, the language employed was unsparing. CBS News documented that the jurist characterized Johnson's actions as constitutionally indefensible and a flagrant abuse of authority. These are not perfunctory admonitions. They constitute a judicial declaration that Johnson operated without legal foundation, that his conduct amounted to naked political calculation, and that he had subordinated constitutional principle to partisan expedience. Such rhetoric from the bench signals a collapse of any credible legal justification. Johnson's defense rested upon an assertion of expansive discretionary prerogative, an argument that the speakership confers unilateral authority over member seating, buttressed by claimed historical precedent. The court dispensed with this reasoning comprehensively. In a written opinion that legal scholars have described as among the most withering rebukes of a congressional leader in contemporary jurisprudence, the judge methodically refuted each contention advanced by Johnson's counsel. Jeffrey Toobin, CNN's legal analyst, reviewing the complete text, noted that the court emphasized a fundamental constitutional allocation. The power to adjudicate contested elections resides with the full House, not with the Speaker exercising solitary discretion. The opinion observed that Johnson circumvented every established procedural safeguard: no committee inquiry, no floor debate, no recorded vote. He simply rendered a unilateral determination calibrated to Republican political advantage. The ruling ventured further still. The judge explicitly addressed Johnson's underlying motive, concluding that the evidentiary record demonstrated a calculated effort to preserve Republican numerical superiority on critical votes by excluding a lawfully elected Democrat. The constitutional question before us is thus clarified. This was not a good faith concern about electoral integrity. It was, in the court's assessment, vote manipulation, a deliberate distortion of the House's composition to secure legislative outcomes unattainable through legitimate means. Such a finding does not merely resolve litigation, it corrodes the officeholder's standing to claim fidelity to constitutional governance. The response from certain precincts of the political right was swift and incendiary. Within hours of the opinion's release, conservative digital platforms erupted in denunciation. Media Matters documented that influential voices within the MAGA coalition assailed the judge as an agent of conspiratorial forces and urged Johnson to disregard the judicial directive outright. Steve Bannon, broadcasting on his War Room podcast on November 19th, characterized the ruling as a declaration of war by the judiciary against the movement and exhorted the Speaker to defy the court's mandate. History reminds us that when political factions counsel defiance of judicial orders, they abandon the very constitutional framework they purport to defend. He contended that the House, as a co-equal branch, bears no obligation to defer to what he characterized as judicial activism. Yet other voices within the same coalition adopted a diametrically opposed posture. The New Republic documented that several Trump-aligned commentators redirected their ire toward Johnson himself, denouncing him as ineffectual, questioning why the matter ever reached litigation, and suggesting that authentic MAGA leadership would have forestalled such a debacle. Representative Marjorie Taylor Greene, never reticent, declared that Johnson's courtroom defeat confirmed his inadequacy for the speakership and intimated that the caucus might benefit from alternative leadership. This fracture within the movement is instructive, for it illuminates the untenable position Johnson now occupies. One faction counsels outright defiance, urging Johnson to disregard the judiciary, refuse Grava's seating regardless, and precipitate a constitutional confrontation. This represents the Bannon doctrine: escalation as strategy, crisis as opportunity. The opposing faction castigates Johnson for weakness, arguing he erred by permitting a freshman legislator to become the focal point of controversy, and that genuine MAGA leadership precludes such juridical humiliation. Both camps express indignation, both assign culpability, yet they cannot reconcile what Johnson ought to have done differently, nor what course he should now pursue. The incoherence is telling. History reminds us that this dynamic is not novel within Trump's political orbit. Consider Jeff Sessions, an early and conspicuous supporter who nevertheless faced relentless public excoriation after recusing himself from the Russia investigation in adherence to Justice Department ethical standards. For 2 years, Trump systematically dismantled Sessions' reputation, demonstrating that prior loyalty confers no immunity from retribution when compliance with norms frustrates presidential prerogative. Then came William Barr, Trump's chosen attorney general, who accommodated the president's interests extensively, issuing a misleading précis of the Mueller report, intervening in prosecutions involving Trump associates. Yet when Barr declined to endorse baseless claims of electoral fraud in 2020, Trump severed the relationship within weeks. Accumulated loyalty proved weightless. Reflect, too, upon Mike Pence, who exhibited unwavering fidelity across 4 years, never uttering public dissent, defending every controversy. On January 6th, however, when Pence refused to exceed his constitutional authority and reject certified electoral votes, Trump directed a mob's fury toward him. Supporters chanted for Pence's execution while the vice president sheltered within the Capitol complex. Even Kevin McCarthy experienced this ritual. After January 6th, McCarthy rehabilitated his standing at Mar-a-Lago, aligned himself fully with Trump's agenda, and executed every directive only to be discarded when Trump tacitly endorsed the hardline faction that removed him from the speakership. Mike Johnson now finds himself ensnared in this familiar pattern. The constitutional question before us is whether unwavering loyalty can ever satisfy demands that intensify with each political reversal. One may demonstrate absolute fealty daily, yet a single legal setback or strategic miscalculation triggers denunciation. There exists no forbearance for defeat, no recognition that judiciaries sometimes rule against even the most determined litigants, no acknowledgement that perhaps the underlying strategy was constitutionally indefensible from inception. The imperative is singular: identify a scapegoat. What then motivated Johnson's decision to exclude Grava? Multiple accounts converge on a single explanation: arithmetic. Grava's presence as a Democrat would alter vote tallies in a narrowly divided chamber. Johnson evidently calculated that her exclusion, even if temporary, would improve prospects for advancing Trump's legislative priorities. Politico reported on November 16th that Johnson aimed specifically to postpone Grava's seating until after votes concerning investigations into the Epstein files and certain budgetary measures. When Republicans command the barest numerical advantage, each vote assumes outsized significance. The absence of a single member can determine whether the majority's agenda advances or falters. Yet Johnson's gambit possessed a fatal defect. Its constitutional infirmity was so manifest that it invited the very repudiation it received. He appears to have wagered that Democrats might refrain from litigation, or that courts, if petitioned, would defer to congressional prerogative. He misjudged comprehensively. Legal analysts spanning the ideological spectrum characterized Johnson's position as foreclosed from the outset. Andrew McCarthy, a conservative former federal prosecutor who typically defends Republican arguments, informed Fox News on November 18th that Johnson operated without legal foundation. McCarthy observed that obstructing a duly elected member while circumventing established House procedures was patently unconstitutional, and that competent counsel should have advised Johnson that judicial defeat was inevitable. When even sympathetic conservative jurists declare your case meritless, the situation has deteriorated beyond salvage. Jonathan Turley, a constitutional law scholar who has provided testimony favorable to Republican positions on numerous occasions, affirmed that the court's ruling rested on sound constitutional reasoning. He noted that representative democracy's essential premise requires that when citizens elect a representative, that individual assumes office. No speaker possesses authority to nullify electoral outcomes merely because the result complicates his legislative arithmetic. A serious republic must ask whether such elementary principles require judicial enforcement to remain operative. The ruling's political ramifications are immediate and substantial. First, Johnson's stature has suffered grievous damage. When a federal court publicly dismantles a speaker's conduct using phrases such as flagrant abuse of authority, the injury extends beyond legal defeat. It becomes a referendum on judgment and competence. Consider the practical consequences. How does one negotiate with adversaries after suffering such conspicuous humiliation? How does leadership project authority when a court has declared its actions constitutionally indefensible? The questions answer themselves. Second, this adjudication fortifies the Democratic caucus considerably. They now possess judicial precedent to invoke whenever Johnson attempts procedural brinkmanship. They can reference this case as documented evidence of Johnson's willingness to abuse institutional authority, validated by federal judiciary. In legislative warfare, such ammunition proves invaluable. Third, the episode exacerbates fissures within Republican ranks. Moderate members, already uneasy with hardline tactics that court constitutional censure, now possess additional grounds to question Johnson's leadership acumen. Their constituents voice concerns about governmental dysfunction, and now their speaker sustains embarrassing judicial defeats atop accumulated grievances. Yet the institutional ramifications may eclipse the immediate political turbulence. This ruling reaffirms a foundational constitutional principle. The speakership does not confer plenary authority. Checks persist. States possess standing to litigate when federal officials infringe upon their citizens' constitutional prerogatives. Courts retain jurisdiction to remedy congressional overreach. For 2.5 centuries, our constitutional architecture has depended upon these institutional restraints to prevent dangerous concentrations of power within any single office or branch. When such mechanisms atrophy, self-governance itself becomes imperiled. This adjudication demonstrates that, in this instance at least, the system retains functional integrity. A state attorney general initiated litigation, a federal judge assessed the constitutional questions on their merits, and the Speaker of the House must comply with that determination, irrespective of political calculation. The precedent established carries weight beyond this controversy. Legal scholars observe that this ruling substantially constrains future speakers contemplating similar maneuvers. Had Johnson prevailed, what principle would prevent subsequent speakers from excluding any member deemed politically inconvenient? The descent toward arbitrary power would accelerate dangerously. The court has now established clear precedent. Such exclusions exceed constitutional authority, judicial intervention will follow, and such conduct will be characterized as it deserves as violation, not prerogative. That boundary serves democracy's preservation. Consider the electoral implications extending forward. Democrats will undoubtedly invoke this episode in forthcoming campaigns, contending that Republicans under Johnson's stewardship attempted to deprive citizens of rightful congressional representation and receive judicial rebuke for the effort. Such narratives resonate poorly with voters who value democratic legitimacy and constitutional fidelity. Older electorates, particularly those cohorts inclined to prize institutional norms and legal order, are liable to interpret this episode as evidence of Republican excess. When a political party suffers courtroom defeat for obstructing legitimately elected legislators, it forfeits claim to democratic principle. History reminds us what transpired here. Johnson attempted to exclude a duly elected Democrat from assuming her congressional seat. A federal court dismantled his justification comprehensively, employing language flagrant abuse of authority that leaves no ambiguity about the constitutional assessment. MAGA constituencies now fracture over whether to assail the judiciary or repudiate Johnson himself. This transcends one speaker's legal misfortune. The constitutional question before us is whether congressional leaders may wield institutional authority for naked partisan advantage, or whether our constitutional framework retains sufficient resilience to impose correction. Had Johnson succeeded, we would inhabit a republic where speakers could arbitrarily exclude opposition members whenever electoral arithmetic proved inconvenient. Representative democracy cannot function under such conditions. The court's opinion reaffirmed that axiom unequivocally. The coming weeks will prove determinative. Johnson must choose whether to comply with judicial directive and seat grava, thereby provoking elements of his base who demand defiance, or pursue further litigation and invite additional humiliation. Simultaneously, the MAGA coalition must resolve whether Johnson represents a victim of judicial activism or merely inadequate leadership. That internecine conflict already unfolds conspicuously, and its trajectory promises only greater acrimony. A serious republic must ask whether such dysfunction serves any interest beyond spectacle. The Republican conference grows more fractured, outcomes more volatile, and constitutional norms more imperiled with each such episode.